the event.
Namaste.
Yeah, she is also here. So really, I'm very, very thankful to you for accepting our invitation on a short notice. I know you are so busy nationally and internationally.
You inspired me. In fact, I wasn't aware about the government planning to celebrate the 4th June 67th anniversary of enactment of Copyright Act. The moment you told me, then I started writing an article. So that I put it on my LinkedIn because it is too short time to reach Live Law or any others. So I just published it on my own LinkedIn as a LinkedIn article. The series 2 is coming up once I come back from Japan. 22nd June is another happening. That is the amendments of 2012, which I have done, that got enacted that day.
Okay.
So in the future steps, I'll be writing. So what will be the future of copyright beyond 2012 amendment, especially all the people who are confused because of AI, Chat, GPT, and many other things, which I'm going to cover in brief now and in detail in articles, giving some recommendation to government what they need.
But really, this part of India is very fortunate to have you because we are all very much behind the nation, on these topics. But I am very surprised to see somewhere in the DPIIT report, Andhra Pradesh is leading in the entire country in creating awareness. I don't know, it's because of our presence over here. I don't know.
No. And then they should tell you who are the agencies doing this awareness.
Yeah. So of course, both our NRDC and ourselves.
Maybe I don't think only BK Sahu is doing this awareness.
Yeah.
There may be other people also.
Yeah. That's what I've seen in the annual report of, I think, Patent Office.
Yeah.
SIPM or NIPM, they mentioned in the country, in the state-wise, they've analyzed the awareness programs.
Okay.
And they have given Andhra Pradesh has organized a large number of awareness programs in IP area.
That's great. If that is true, nothing like that. But who is doing that job and how that can be replicated in the other states is important. Who is driving that? That one should find out. And try to inspire other people that look, these institutions are involved, these individuals are involved.
That is true.
Then
someone has to do.
Other will come competing with them. It will be a win-win situation for everyone.
లేదంటే నేను ఈరోజు ఢిల్లీ బయలుదేరాలి 4:30 అదే 4:45 is my flight. సో నేను కొద్దిగా వెల్కమ్ చెప్పేసి నేను అరౌండ్ 3:30కి బయలుదేరుతాను.
అచ్చా మీరు ఢిల్లీకి వస్తున్నారా? ఓకే
ఢిల్లీకి వస్తున్నాను. రేపు అదే మీటింగ్ ఒకటి ఉంది ఇక్కడ అగ్రికల్చర్ మినిస్ట్రీలోను హెవీ ఇండస్ట్రీలోను.
ఓకే
సో మీరు ఎప్పుడు రేపు వెళ్తున్నారా చెప్పాను ఎల్లుండా?
రేపు ఈ పాటికి నేను ఆల్మోస్ట్ రీచింగ్ ఎయిర్పోర్ట్ అనమాట.
ఓకే
ఎగ్జాక్ట్లీ 6 o'clock ఫ్లైట్ ఉంది, డైరెక్ట్ ఫ్లైట్ టు టోక్యో. ఆల్ నిప్పన్ ఎయిర్లైన్స్ అనేది ఉంది, వాళ్ళే టికెట్ పంపించారు. అందులో
I'm very, very happy you are more active after retirement, nationally and internationally. Your flower and fragrance, has been probably when you are in government, you are with so many controls and regulations.
Because now I am the boss, I need not take permission except my wife.
Yeah, that is good. Yeah. It's great. One side you are going to US, other side you are going to Japan to talk on this subject. It is a great accomplishment. Raghavendra garu Telugu bidda, Usmania, and he started his career with a very humble beginning as a library science, DLS. Bachelor of Information Library Science, then goes to the highest qualification in intellectual property right, is leading the country's negotiations in WIPO, intellectual property rights. We're very lucky to have you here, and we would like World Intellectual Property Organization, UN board, and that decides the global momentum of intellectual property right growth strategies, planning. So I think we can start now. How many people have joined by? At least 100 people are there, though the response is phenomenal. Raghavendra Garu,
Yeah.
there are 975 people have registered. I never expected your popularity is so high in the country.
No, more than the subject is such thing. Everybody wants to know about the artificial intelligence and copyright.
Madam garu join ayyara. Vijayalakshmi madam. Madam, have you joined? Vijayalakshmi madam? Professor Vijayalakshmi garu. Professor Vijayalakshmi garu. Vijayalakshmi. Kaide Vijayalakshmi. రెండు ఉన్నాయి, మూడు ఉన్నాయి.
Hello. Yeah, I'm in a meeting. Can you please ring me up after 6 o'clock?
Yes. Okay. Yes. Thank you. Yes. Already third, fourth, no.
Yeah, madam. Yes, we are able to see you. Madam, we are able to see. Yeah, right.
Yes, sir. I'm also able to see all of you.
All of us, right? Good, great. Raghavendra garu also is there. You're able to see him?
Yes, sir.
Yeah.
Namaskaram, Vijayalakshmi garu.
Namaskaram, sir.
I think you know each other, na?
Yes, sir. We know.
Okay, great. Okay, friends, let us start our today's program. Good afternoon to one and all. It is a great honor and privilege for me to welcome you all for this very important, I would say it is a mini national webinar on artificial intelligence works, authorship and ownership under the Copyright Act 1957. which is jointly being organized by Dr. B.R. Ambedkar Law College and Institutions Innovation Council of Andhra University. We are very grateful to all the 900 and odd registered participants, our beloved Vice Chancellor, Professor PVGD Prasad Reddy Garu, our respected Registrar, Professor V. Krishnamohan Garu, and very kind-hearted Rector, Madam Professor K. Samata Garu, and Professor V. Vijayalakshmi Garu, Principal, Dr. B.R. Ambedkar College, Andhra University, for their constant support, guidance, and mentoring in organizing this event today. We cordially welcome Dr. G.R. Raghavendra Garu, the just retired Joint Secretary, Department of Justice, and also he served as a Joint Secretary in DPIIT, and also served as a Registrar of Copyrights, Government of India, as a keynote speaker in today's webinar. In fact, Copyright Act 1957 is the oldest intellectual property act in India, and all the other acts like Patent Act, Trademark Act, Copyright Design Act, GI Act, all came subsequently into existence. The Ministry of Commerce and Industry is a nodal ministry to implement all the IP acts in India. The Ministry of Commerce and Industry directed all the DPIIT IPR chairs in the country to celebrate the enactment of Copyright Act 1957, which was enacted on 4th June to create awareness of the benefits of the Copyright Act to the society at large. We are therefore organizing this event today to create awareness on copyrights, particularly with reference to artificial intelligence and copyrights, because the emerging importance of artificial intelligence, which is a subject matter covered under the Copyright Act. You are all aware, artificial intelligence is making headlines everywhere in the world, and we are hearing artificial intelligence is going to rule the world as AI is impacting all human activities like education, health, industry, security, whatnot. All human spheres of activities is getting impacted by the artificial intelligence. So there is a public opinion also that the existing intellectual property laws are not adequate to protect the AI creations, and different countries are evolving their own IP laws related to artificial intelligence. So we heard also recently one of the global company, appointed as its CEO a artificial intelligent machine, is a AI based machine, has been appointed as a CEO, and that artificial intelligence machine is managing the entire company's operations, and the company also made substantial growth and profits. If that is going to be the new norm in future, then we all know what happens to our own existence and our intellect. The human intellect, we all claim, we are superior creations of the God. I don't know what is going to happen to our own existence if the artificial intelligence machines are going to replace all the human activities. So as per the recent parliamentary standing committee report, also if you see the report, what it says, a 1% increase, in trademarks, and 1% increase in patents, and 1% increase in copyrights, will result in 3.8%, or 2.8% and 6.8% of the FDI. That means the FDI, foreign direct investment into the country, also usually depends on this protection of these intellectual property rights. Among all these three intellectual property rights, copyrights contribute substantially to the FDI if there is a good protection for copyrights in any country. So that shows how important the copyrights in the Indian economy, not only in Indian economy, even for the global economy, And of course, if there is more FDI, more GDP and more employment opportunities and the poverty alleviation, all these things are possible. So because of this economic benefits of copyrights, it also offers enormous opportunities for fraudsters, to copy those things, violate all the copyrights and entering into the piracy domain, Because of that, piracy is a parallel economy, As a result, the rights of the copyright owners, or rather sacrificed. That is why there is a important need and urgent need to create awareness among the general public about the importance of copyrights. Copyright means is not right for copying. It is the other way. Preventing others to copy your creative works. That is the copyright. So therefore, there is a huge requirement to create awareness on the copyright laws and their impact on AI technologies. So, and we are having the best speaker today on this subject, Dr. Raghavendra Garu, our Telugu Bidda, and I welcome Dr. Raghavendra Garu and all the distinguished participants, knowledge seekers, on this very important topic, artificial intelligence. We are all, in fact, living in the age of artificial intelligence. If you don't equip yourself, and if you don't equip yourself with the laws governing the artificial intelligence, we will be definitely very much left behind. It is very, very important for all of us to understand the various developments happening across the globe through none other than Dr. Raghavendra Garu is a nationally and internationally known sought after resource person to speak on this Artificial Intelligence and Copyright Act. And I wish the program a great success. And I hand over the program to Dr. Anandya to carry forward as per the agenda. Dr. Anandya, over to you. Yeah.
Hello, everybody. Welcome to this program today. So now I would like to request our guest of honor, Professor Dr. V. Vijay Lakshmi, to enrich us on this topic today. The floor is yours, ma'am.
Yeah. Good afternoon and my namaskarams to all the dignitaries. Registrar Sir, Chairperson IPR Cell AU, Raghavendra Sir, whom I think we have shared many floors and seminars, etc. I am being known to him, and other colleagues, student friends, and all the other invitees. Perhaps the retired madam has also joined, I think so, and all the other dignitaries and the scholars. So today's webinar topic, which has been decided as artificial intelligence protection and all. But before delving deep into the topic, which of course Raghavendra sir is going to deal with, I would like to give a brief introduction, or rather, how copyright protection is thought to be a suitable arena for protecting the artificial intelligence. Now, it is in the brochure itself, it has been said that 67 years of the Copyright Act, but then it is more than 300 years when the first Copyright Act was enacted in 1710, that is the Statute of Anne. And then we were not calling it as a Copyright Act because that term was not familiar in those days. So it was simply called as the author's rights in those days. And with all started, all the intellectual properties, whether it is a copyrights or whether patents, trademarks, or any other form of intellectual property, all these have gained up its momentum only after the Industrial Revolution. Because till then, the mass copying, the trend of mass copying was not there. And nobody was bothered about that some third person will make copies of it and exploit and use in the different ways. And the person, the real genius person, the person who is behind the creation of these intellectual works, he will remain as poor as ever. He will not try to reap up any kind of benefits and all those things. So in the copyright, when we say the industrial, actually copyrights, patents, we categorize the IPRs into two broad categories. One is the industrial property and the other is the copyrights. So industrial property that deals with the patents, trademark, designs, nanotechnology, biotechnology and all. So they are industrial property we call. This is a property. It is not industrial laws. That is a different thing where the labor laws and all are entered. And coming to the copyright area, So the copyright area, actually we make it as a idea expression dichotomy, we call it as that. The industrial property dealing with the patents, trademarks and all, they deal with the ideas. Our ideas, whatever they come out from our brain, we protect that, how to protect those ideas. And the other thing, that is the copyrights, they basically protect the expressions. So expressive field, we use our brain for basically to for creation something and express ourselves something. So coming to how do we express ourselves? So there are various ways, various modes through which a person expresses oneself. Right. It may be a spoken word or the written word. It is a composition of the music, arts, and whatnot, cinematograph, films, and of late, when the computers were invented, the computer softwares, the entire copyright industry is going to computer software industry is being protected through the laws of the copyright. So what is the basic subject matter of the copyright here is that is the literature work, musical work, cinematograph films, sound recording, computer programs, and all these things, and of course, the field, whether it is in the industrial property, that is a patents, whether it is a copyright, the subject matter of each category of these fields are open. The list is open. It is not that it is once created and that's all. Every one day or the other, a new thing is coming up. Whenever the new thing is coming up, naturally it is posing a challenge for the authorities, for the government to how to address the issues that is being raised up because of the new invention or a new form of expression. Because sometimes it so happens that first the things will be created, and that whatever the things are created, that will pose some kind of challenges, and to address the challenges the laws are made. Now here, in case of this artificial intelligence and all, I'll try to give a parallel example here. Now, what happens is that generally when we write, say a writer has written a book. When he has written a book, so what can it be? What uses the book is having? What things it opens up? The books which is been written up is to be published in the book form. A story may be converted into any other form. A film may be made, and so many things may. So one writing of the book that give rise to so many uses of that, and then being the writer, he is the owner of the book. Now, till the artificial intelligence and the computers, these were invented, the ownership of these works, whether it is a literature, music, film, sound recordings, or whatever it is, they are being created, all the ownership rights remained with the owner, that is the creator of the person. But slowly, because things have changed, because the owner, I mean the author, whether he is a writer, whether he is a composer, whether he is a filmmaker, he himself cannot market and do the things that it should reach at each and every person. So that's how a third person has entered, and we call them as the publishers. So these publishers, they take up the work from the creators, and they see that these works, they are multiplied, they are marketed, and ultimately it is reaches to each and every public. And in return, they used to pay some kind of royalties to the creators of the knowledge and all. So long we understand this as traditional form, how the copyright laws, the work, what kind of laws that are being created. So here, because the creator himself is a person, so he is the owner, and Copyright Act itself confers a lot of rights to the owner. So, okay, whatever the rights, he will use up those rights and all. But when this question of artificial intelligence means what it is, how that the machines, the computers, once the computers, they were invented right in the 1940s, and that has grown up, and how the things, they are being getting transferred from one mode to the another form. We are all witnessing these things. Say how the digitalization has changed. Now we need not just go for a typewriting, taking one page, another another page, and all this. So once you have digitized the work, any number of the copies, it can be downloaded or printed out. It can reach to the n number of the public without or the least cost it can go. So this is how it has changed. What other things that have been given rise to the digitalization, computers, and then the field has increased, computerization, they get the robotics and all. So there, the forms that is now one need not get a translation. Take for instance a translation. A translation, first of all, is to be written in a main language that is to be translated by another person, and then it may be again translated, the copies may be distributed, all those things. But when these machines are being adapted in such a way that these translations, etc., they can be done by the machine itself. Similarly, there are many other things, whether it is in the field of the music, whether in the translations, whether it is been doing some kind of machine work. So it is what is happening is that slowly they are replacing the human involvement slowly, and the machine is taking up. And machine is taking up, and that is creating, and that is making. Now, nowadays, you must have seen in the news channels, especially just since last 2 days, I am observing the weather report, the last news item, news channel, weather report. Now, there they are using artificial intelligence, AI, and that one lady will come. She will be almost look like a news reader, and she will read out the weather report, which is already programmed and fed up in the system and all. So this is what how it is changing. That means even if the news reader is absent, show can be managed without a human presence. So this now, okay, creating, there's a lot of help is being extended or is made available to the public. Okay, this is good. But then what is the nature? What is going to happen? Who is the owner actually? Who will enjoy those things? In the Copyright Act, it says that the author is the first owner of the copyright. Okay, he will enjoy all the rights. But when such works are created by the machines, will the copyright ownership goes to the machines? Who will monitor that? So these are the different things that are now presently become a challenge for the authorities. And to what extent? What is the extent? Because there are many other issues are also there with this artificial intelligence. Why? Because it is not only replacing a kind of work with another work, but also it may replace the human involvement to the least. So, in that case, how far, to what extent these are to be protected? What laws are there at the national laws and at the basically at the international level? What is the international community is thinking of? How to address these issues? Because this is not something which is limited to a particular country. It is there with each and every country. All are slowly one day or the other day. Every country they have to adopt these things. They too have to face the challenges which are being made here. And in this regard, with regard to the ownership issue, that is the basic issue here, where the artificial intelligence that takes up here. And again, the another issue is that how long this protection is to be extended. Because generally, when we say protection of the copyright, the act says that it is for the life of the author plus 60 years. So what will happen if the work is created by the machine? Because the machine is not an individual. So it is a machine, artificial person. So is it that the rule of the 60 years from the date of the publication, will that arrive? So the term of the protection, again, that will happen. Infringement area, how the infringement issues are being resolved, how they are to be attended here. Then what exceptions can be? Is the traditional exceptions that are being cited under the copyright, will it make it available to the works created by the artificial intelligence and all? So these are the some of the issues that are to be, that really requires the attention of the authorities, the state and international communities, and of course the forums where such discussions are to be made. And I hope Raghavendra sir will deal all these things in detail and enlighten us on this subject. So with these few words, I thank the authorities and hand over the mic to the chairperson. Yeah. Thank you.
Thank you so much, ma'am, for your talk. I hope the students gained a lot of knowledge from your talk. Since you are from the law college, so you will be able to tell all the students from the legal
Not many
perspective.
joined, madam. They are joined.
Yes, yes. Thank you so much, ma'am. Now I would like to like to request our respected Registrar Garu for his talk, for his short speech on this. Yes, message. Yeah, this is a message for all of you, for all the students who are here. We are very lucky to have Registrar with us today. So please listen carefully what he has to say. Yes, sir, it's yours.
Yeah, good afternoon to all of you. The invited speaker of the day, Raghavendra, who is an expert in the domain copyrights, and also our learned professor, who is guest of honor on this occasion, Professor Vijayalakshmi, who did considerable work on copyright, who has spoken just before me, covering several dimensions. And also in the opening remarks, Professor Purushottam has explained the purpose why this webinar is organized is to sensitize people into the present dimension of emerging dimension of copyright law. It is several centuries old law as observed by Professor Vijayalakshmi Garu. Definitely. And as a layman, because I am remotely connected to copyrights, I am a management professor, but still, as a layman, I'm going to share, few of my concerns on this occasion of this very useful, highly contextual topic of the day. As I understand, copyright is a legal right which provides protection to the original creators of human mind and intellect. So copyright protection in India, as I understand, protects creation, anything that you create, which is not mere idea. Therefore, once the creation is an expression of an author and not merely an idea, then such work may be protected. This is what I have understood as the scope and nature of copyright law. I've also understood when I referred material under Section 14 of the Copyright Act of 1957, which defines copyright as an exclusive rights of the owner to do or authorize the doing of any acts in respect of a particular work, publication, adoption, translation, etc. Now, interestingly, what is happening in the recent past, one need to examine. Since we invented computer, as I understand from 1970 onwards, computers are used in creating different art forms. Although they are in very crude form in earlier years, but definitely the robotic artists who are involved in various types of creative works for a long time, ever since we invented computer, producing such works of art, and these efforts continue today with several very advanced software tools and also more specifically the artificial intelligence. Such revolution undoubtedly is underpinned by rapid development of machine learning software, as we see, which is a subset of artificial intelligence. All of you hear so much about Chat GPT. On similar lines, there are many other such artificial intelligent softwares. that are going to perform several jobs on their own as a standalone system. So now, anything that is produced by the artificial intelligence, can we first of all claim as a copyright? If at all such invention is entitled to a copyright, who is the real owner is the important issue. So I think this webinar, with the help of expert speakers, going to clarify, can you adopt artificial intelligence for copyright? How does artificial intelligence affect copyright? Can artificial intelligence own copyright in India? Suppose ChatGPT, can we grant copyright to ChatGPT? Because this is the artificial intelligence that has written a book. As all of you know, with the help of ChatGPT, you can write books also. Now, who is the author? Is it ChatGPT or the human? Is also going to be a great concern. Addressing, therefore, ambiguity and the issue, how artificial intelligence and copyright, what type of interface is there, and what type of conflict of interest is going to become present in today's context of use of artificial intelligence. Also, machine learning software, as all of us know today, which is a subset of AI, is also producing several works as a standalone autonomous units. When machine learning is producing different forms of art without human intervention sometimes, and who has to be given credit? Is it the machine learning software, or is the human who has written the software? These are all probably going to be the very perennial issues which can be discussed at length. Maybe experts like Raghavendra Garu and also Vijayalakshmi Garu and Professor Purushottamji can contribute in mitigating that ambiguity so that whether amendments are needed in the age-old copyright law in the context of technologies which are evolving, shaping, reshaping. As a result, the basic paradigm shift one can witness all around. So what type of copyright law is going to protect such innovations, inventions, is going to be matter of deep discussion. In fact, there is also terminology that has entered into this artificial intelligence like deep thinking. How this deep thinking is done by not humans, by the machines, so that a complex problem can be resolved. And I'm so happy when a robot can manage as a CEO, how, the decisions of CEO, whether they are human or mechanical. Definitely they are mechanical. If this is the contribution, how you are going to address such issues in the copyright law with reference to artificial intelligence and their effect on copyright is going to be a concern, I believe, with the help of expert speakers on the occasion and the students who are enrolled in large number, they are going to get clarified what are their doubts, apprehensions, or enhance their knowledge in order to, sensitize people in this particular domain. I think this webinar is going to help facilitate, and I look forward for interesting points to be noted on the occasion, and probably at least few minutes of time should be spent on the interaction towards the end so that any webinar is going to become fruitful. I look forward and wish the webinar a grand success. Thank you all. Wish you all the best.
Thank you, sir. Thank you so much. Well done. Thank you, sir, for your very thought-provoking ideas and questions you have posed before the experts. even the experts have to ponder themselves whether really the solutions are available readily. Because as I mentioned in my talk also, countries across the globe are started now examining their own laws in the light of emergence of the artificial intelligence. And Dr. Raghavendra Garu is now studying all the countries' laws, artificial intelligence and copyrights, and probably you may get some satisfying answers from his address. Thank you, sir. Thank you very much. Yeah.
Namaste.
Raghavendra Garu, I will hear your talk while traveling to airport. Kindly.
Started at 4 o'clock.
Okay.
Okay. Right.
Check-in చేసావా?
Second Jason.
No problem. You can stay.
You
Oh,
can
15 minutes
introduce.
ఉన్నా.
Can introduce.
Sir, he is worried. Don't worry. Huh? And I can arrange, special entry also. My student is there as chief security officer. He will be here at least for next 15-20 minutes.
Okay.
He will start exactly at 4.
Oh, 4 is not too late.
నాది బాయ్.
Okay, right.
నీకు నెంబరిస్తాను వేణుగోపాల్ అని చీఫ్ సెక్రటరీ అక్కర్లేదు నేను మొన్న 4:30 వెళ్ళాను.
Okay. Okay.
Okay, participants. So now I will briefly introduce our keynote speakers today. Whatever I can see on my screen, that's quite a big and a wreath. So we are not going to read it out, the whole of it. That will take 1 hour. So, sir, I will just read out few of the things that I feel will be important. So, Dr. G.R. Raghavendra is a retired civil servant from Central Secretariat Service. He worked as Joint Secretary, Department of Justice, Ministry of Law and Justice since January 2017. He was also Mission Director for the National Mission for Justice Delivery and Legal Reform. He was, whoever you are joining, if you can mute yourself, that will be really great. He was also Joint Secretary in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India. He is an intellectual property rights law expert focusing on IPR protection and emerging new technologies, competition law, and international treaties. He has attended many of the WIPO, SCCR meetings and FTA negotiations as a member of the Indian delegation. He made significant contribution in many of the treaties like Beijing Treaty on Audiovisual Performance 2012 and Marrakesh Treaty that facilitates access to published works for persons who are blind, visually impaired, or otherwise print disabled. He has contributed to the revision of the copyright legislations of Bhutan, Cambodia, Myanmar, and Nepal as a copyright expert. As a resource person, he has given lectures and talks on copyright and related rights in various international and national seminars and workshops organized by WIPO and several law school and universities and institutes all over India. So there is a short description of his educational background also. He has completed his PhD from Guru Gobind Singh Indraprastha University, New Delhi. He holds several degrees and postgraduate degrees, namely MA in Developmental Studies from Institute of Social Studies. Then he holds MPhil in Ancient History and Archaeology from Osmania University. He was a GRF scholar of UGC as well. He also holds an LLB degree from Delhi University, LLM in IPR from Guru Gobind Singh University. He completed his bachelor degree in Law, Library and Information Sciences and PhD degree from...
Thanks a lot for the generous thing. I think I'm just excited to begin.
Thank you, sir.
Many students are there and people are there.
Very accomplished person in the field of WIPO, right?
Right.
So you are the right person Professor Purushottam has chosen. I am very thankful to him for introducing you to our, target student population. And definitely, you will be sensitizing the future generation who will think on those lines. Thank you very much for accepting our invitation.
Yeah, thank you. Hare Srinivasa, Vande Mataram, and respected Prasad Reddy Garu, the Vice Chancellor of Andhra University, Krishna Mohan Garu, Registrar, Dr. Vijayalakshmi Garu, Professor, and my friend and former NRDC Chairman Purushottam Garu. And thanks for your initiative for this thing. And Endaro Mahanubalu, Andariki Vandanamlu, all the faculty, researchers, and students. It is a very important thing to celebrate these, fortnight celebrations. We have the 67th anniversary of enactment of copyright law. The copyright law 1957 was enacted on the 4th June, and 7th, there's so many changes took place. I'm going to cover that, not in detail, but in a nutshell. So for the beginners who should know that, despite British introduced copyright law in India, before in fact British introduced, it was the Mumbai High Court in Macmillan versus Khan Bahadur Shamsul Jaka case. It said that, Macmillan being a publisher, their copyright infringement being done, and their right have to be protected. There is no national legislation in India. So the East India Company, the British government, can extend the British copyright law in India. So later only in 1847, the first UK copyright law was introduced in India, and standalone law was introduced in 1914. It's totally based on the UK Copyright Act 1911. Since it wasn't sufficient, so once India became independent and 1957 we introduced this copyright law, which we are implementing, and there are many amendments have been done because there's a dynamic technological changes were happening. To address them, and also India become the member of the Berne Convention and then various international convention scheme, as technology kept changing, because Berne Convention protects only literary artistic works of authors, whereas there was a need for introduction of a new convention called Rome Convention to protect the rights of performers, phonographic companies. The music industry in India was becoming great in 60 itself, and also the broadcasting organizations. But that didn't end there when this recording piracy started in 70s. Then new convention was needed in 1971. The Geneva Convention came. So India is one of the first countries to sign the ratified treaty to protect the robust music industry in India. And then technology started coming, then the broadcasting started spreading, not only from the terrestrial to satellite, and then the stealing of satellite signal before it reaches your television. That became a big headache. So Brussels Satellite Convention came in 74, but that did not address the D2H, the direct to home broadcasting, which was started appearance at the time. So they did a historical mistake by having a treaty only satellite to satellite broadcasting, but not the DTH. Then came internet. So internet came, a few issues were addressed in the TRIPS agreement when WTO finalized the TRIPS agreement as one of the bouquet of agreements in the Marrakesh, which came into effect from the 1st January 1995. What happened? They did address the computer program issues, whether it can be a patentable subject matter, a non-patentable subject matter. That was decided. A flexibility was given to countries, and then come to copyright. India and other countries preferred giving copyright protection based on the literary work definition given in the Berne Convention, Article 2, that the expression which is written in any form or any manner. That's what the computer software, computer programs written in source code and program code are recognized as a literary work, along with the computer databases. Now the disruption started, online networks came after that, the digital rights management came, and the any circumvention of these digital rights management devices. The encrypted devices they are put there to protect the content online. You can't download illegally without creating your login and password. Pay online because anything is done without the consent of the author or owner, without paying a compensation or a royalty as a fees infringement. You must have seen in COVID times. We're all locked down at the homes. We couldn't go to the theater, multiplex, PVR, any other films. So we sat at home. We got bored with the television channels. We turned to the new technology called streaming channels like Netflix, Amazon Prime, and all that. We paid only 500 rupees. We created our login, we created our password, and like sincere people, we paid and watched a number of programs. Maybe web series, maybe a new film, regional language film, Hindi film, or other our own mother tongue. Telugu is a robust industry. Whether it is Bahubali or RRR, you must have watched that umpteen times on the screen, sitting at home in your drawing room. So these things were happening. Then came our friend called artificial intelligence. In many forms, it has come. So how it is going to be? Artificial intelligence and copyright issues. Of course, Professor Vijay Lakshmi Garu opened the screen, set the stage before I started. Thanks for that. Now, who is the author? Copyright is a legal right given to, exclusive right given to the authors or creators. Who are these authors? Authors of literary work means the person writes a book or an article, publishes an article, or writes a poem or a film song. These are all literary works. Who is the author? Human being. He is a natural person. How can you give the same similar rights to a machine which has no life? The artificial intelligent machine. Can you give that? So that is the big issue. Then comes the another important thing with musical works. So there are generative AI. Generative AI apps have come. They create music. They mimic the style of the famous music creators, Jandiala. The Andhra Telugu film Jandiala was a famous, as a kid, I know, the all very good songs were created by him. Or nowadays, the latest Kiravani, the music composer. So these machines can create a music of a dead person's music after learning various tunes he has created from the bouquet of data sets after learning these machines create of a dead person music or the living person like Kiravani. So how come a machine going to be a right owner or a creator or copyright owner? Then comes another famous, not only the Chat GPT I'm talking about. Chat GPT is a very well-known generative AI. There are many generative AI things like mid-journey or stable diffusion. These are the next level, deep learning and machine learning generative AI apps and machines, algorithms. Ghantasala Garu is not alive. My first favorite singer. Then SP Balasubramanian. So now a new film is being directed by Rajamouli Garu, written by his father Vijayendra Prasad. Just now, 1 hour back, I just spoke to Vijayendra Prasad Garu, who is the famous scriptwriter of Bahubali and RRR. So these guys are going to involve. They wanted a traditional song, either sung by Ghantasala himself or Balasubramaniam himself. What will happen? These gentlemen are not alive. But these generative AI, they start learning how Ghantasala sang. till today, Shiva Shankari, sorry, the famous classical song sung by Gandasala. When he was alive, he said, the most toughest song sung by me in entire career is Shiva Shankari. That is the song. And then there comes Balasubramanyam. So it's just the mimic the voice, mimic the style, and the machine starts singing. It's a new lyric written by maybe Kiravani ji or anyone, and the famous lyricist. So, and their relatives will come and file a case against them. Are you engaged? You don't want to engage into that problem, and you make your machine sing like Sonu Nigam, Shreya Ghoshal. With that voice, they're singing a Telugu song. I know Sonu, a good friend of mine, he sings a lot of Kannada songs. Not heard singing in Telugu. If this happens tomorrow, Sonu Nigam doesn't know that his voice has been mimicked, his style has been mimicked, even Shreya Ghoshal or Suniti Chauhan. So how it is, infringing their copyright, or because the performance by these people, these machines are copied. So how it is going to be protected? These are the various things. And before artificial intelligence came into picture, one great thing happened. So that is the famous Naruto monkey case. So Naruto is a macaque monkey found in Indonesian jungle. When David Slater, the English photographer, went there, was looking for an angle there. Before he reached his camera, which was set on a tripod, this monkey came, the Naruto, which he called that macaque monkey, started taking selfies. He took selfies so beautifully, and you and me may fail to compete with that smile the macaque monkey has given that beautiful selfie. So he loved it. He started because he's the owner of camera. So who is the author of photograph? What Copyright Act says? Copyright Act says person who clicks the camera is the author. So the moment he started monetizing that, the people for ethical treatment of animals, the PETA, filed a case in district court in USA that this guy is violating human rights. The author of that photograph is that monkey. How can he commercialize that? Then happened, he won the case up to the first court of appeals, but matter went to Supreme Court. He had a after court settlement. He said, okay, don't drag me to the Supreme Court. I'll pay 25% of my earnings for the animal welfare society. Then social media people asked me. Then I told the person is the author of literary work or artistic work or a photograph or a computer program. You take any work, person, what is the definition of person? It's not given in the Copyright Act. So where is it given? You got to go to General Classes Act. There it says person means natural person or a legal or juristic person. So Dr. Vijay Lakshmi Garu writes a book. That is the annual report of the Law School of Andhra University. The various activities they have done and everything. Then she, as an employee on a contract of service, so she will get only the right to paternity. Her name is recognized as author of the book, but the owner of copyright will be her employer, that is Andhra University. So copyright goes to them. Then what happens? What happens in this case? Can the artificial intelligence employ that machine in your law school can be treated as an author or a legalistic person? So this question comes. If you see the corporate law, the concept of legal person or juristic person has been recognized for any institution or entity which has no life. But the institution and entity is managed by a group of people. So what I suggest that a machine can never be given a copyright or intellectual property right, but the owner of the machine can be given the legal personality right or the juristic personality right. Then why only a person should be given right? Question comes. Because you see the entire theory of intellectual property based on the concept of exclusive rights game. They protect the intellectual creativity, the human creativity, not the machines. So machine have been involved right from the beginning when Gutenberg invented the printing machine. So why that right has not gone to the printing machine? It is printing the book. Man is not involved. His only typesetting is doing. The machine prints the book. Now the modern technology has come. The modern technology employed by the publisher nowadays have done away with that old model of typesetting of books. Remember when I was walking in the streets in Telangana when I was born, where the printing machine shops used to there. They used to print wedding invitation and various things and all that. There's still a lot of typesetting character metal based printing technology used to be there. So printing technology has taken lot of changes with the innovations and patenting. The way printing is to happen whenever the child, when printing has to happen in the 15th century, Gutenberg machine has changed. Now all digital printing is happening. Everything is automatically done. The books come out. The introduction to copyright law or intellectual property rights, either written by Dr. Purushottam or by Dr. Vijay Lakshmi. That physical book is out. So they may sell, digitally the soft copies, provided there is some other, business model is there. Then only this is the natural right given to human. This right cannot be taken away. This is the natural right given to the humans. It is an inherent right, the copyright given to them. So that cannot be taken away and given to a machine. So that's not possible. Then comes the most interesting aspect of this thing, the personality of that person who writes books, the author's personality. Look at the author, Sri Sri, who used to write a lot of songs and all that. And Pillala Marri Pinavira Badrudu, you must have heard his name. And Suravaram Pratap Reddy. Or you take your own Ramadasu, Potana, Vemana, Srinathudu. So, or you just move around the Prem Chand, Rabindranath Tagore. Now let us we have Chetan Bhagat. All these people written books. Look at the personality development of these people. The socio-economic conditions, their family, their culture, their religion they followed, the traditions they followed, everything impact a person expressing and writing a book. Maybe it's a fiction or a non-fiction, a person writing a non-fiction law. So what is his exposure, his reading, his learning mechanisms, all the learnings done by human beings. It is done physically and it is a pedagogical learning, and your institution is the best example of that physical pedagogical learning. So it's not that easy. It takes years. Law degree itself, nowadays the 5-year law degree is there. We all pass a 3-year law degree and PhD minimum 3 to 5 years. That differs. And post-graduation 2 years, LLM or any other. Of course, nowadays that is being shrunk to 1 year post-graduation degrees most of the places. But that's immaterial. You see the learning mechanism of humans and the learning mechanism, the machines, totally different. That is machine learning, that is digital learning. Coming to another theory, incentive theory. The very birth of the intellectual property law, whether it is a patent or a copyright, the central to that is incentive theory. What is the incentive theory? Like personality theory, the person in a creativity extended to the society. With that, then also there is a utilitarian concept in that. For the betterment of the society, he writes or he creates. Coming to the most important incentive is why exclusive rights, the monopoly rights, exclusive rights are given to author, because he will sustain with that compensation, whether royalties or fee given to him. His writing has become a profession for him. He keeps on writing and selling that books. That becomes his livelihood. And you keep on reading his books because you like his books, and the knowledge is going to propagate and disseminate through his books to you. Whether that is the non-fiction or subject book needed for the academics, or the entertainment, other knowledge books, which is the fictional books, or scientific fiction books, or learning books. I know many things have come in the market. All this central to protecting the copyright, the exclusive right of the copyright. So everything is human centric, natural person centric. How can you give these rights to a machine? So, what I always say ad nauseum, machine is a machine. Don't put spirit into that and start treating like a human being. And don't say, oh, it's a gray area. We don't know what's going to happen. Look at this now. People, experts, some say, who are very fond of promoting the rights for artificial intelligence, which I always oppose doing so. Why? Because I already told you the basic theories of intellectual property rights against granting rights to these machines, because these are non-humans, not natural persons. Only thing is, even though tomorrow you take a decision to extend the legalistic person status or a juristic person status, that is given to people who are handling this. That's what the US Copyright Office. I thank my friend Shira Perlmutter, who is the registrar of copyrights. Their decision when the Stephen Thaler filed an application on behalf of his artificial intelligence machine called Dabus. Dabus is a generative AI machine. You know what Dabus did? It did learning mechanism. Learning of whom? There is a 17th century Spanish painter, Rembrandt. His painting, it learned and created similar. What is the brush movements he employed? There is a realistic painter, the portrait painter, and what are the colors he used? What are the styles he has done? More than 100 photographs and portrait was fed to this machine. It learned it out of that and created, let's say, now is ask the machine, the doubles. After it has learned, I just give one passport size photo of Krishna Mohan Garu or Purushottam Garu or Vijayalakshmi Garu. Immediately it starts creating as if that 500-year-old back when Rembrandt was alive, he is alive now sitting in front of you and doing the portrait. Similar manner it will create. Now they said there is originality. They said, what is the test for the copyright? Originality. Next, fixation. This has been done. Please give a copyright. There is no need to go to Copyright Office. Copyright is automatic. When the Berne Convention came in 1886, There are no formalities for copyright, unlike patent. There is no need for registration of a copyright. Then why 50 countries, odd countries out of 192 WIPO countries, member states, including India, have a copyright office, a registration system is there. When I was registrar in 2014, I started e-filing, digitization. Whatever 500 rupees fee you can pay online, debit card, credit card, internet banking, whatever facility I said. Now the more things have come now, the Paytm, GPay, and other things, Google Pay, Phone Pay, all these digital payments have come. But all these things are being done because copyright registration gives additional protection to you. Certificate given by office is a prima facie evidence. Who files the application for that? Person, interested person. Who is the interested person? Maybe author. Author is Dr. Professor Vijayalakshmi Garu, has written a book. But she has transferred the rights, copyrights to the publisher. When publisher files a copyright registration, he has to take no objection from her, and that no objection certificate is submitted. Publisher, as a legalistic person, who is entertaining the life of the author plus 60 years duration for that literary work, is getting that right. But Davos can't get it. What Stephen Toller has done, this AI data analytic expert, he created this generative AI machine and filed a copyright. That is, machine is the author of the Rembrandt portraits. Copyright office rejected it. After that, also again registered. Why they rejected? Out of that, machine didn't start thinking that I will paint like Rembrandt, realistic, or start painting like Van Gogh, who is an expressionist painter, or start painting like our Salvador Dali, who is a surrealistic painter, or Picasso, who is a different kind of cubist painter. There is a different schools of art. Artists, because of their style, new style of modern painting they started, that became a big hit, big school. Many people joined that, started imitating them. Even though style is imitated, they started painting originally in a differently from Picasso. There are so many cubist painters are there, so many expressionist painters are there, so many pointillistic, realistic, or surrealistic painters are there. Why there is no copyright violation? Because they must have taken that style. But if you compare these artists, the group of class of painters, totally different. Style may be the same, but the application is different. But artificial intelligence is artificial intelligence. It will learn what is fed to it, what is available in the internet or digital networks or digital databases. It can't go beyond and start learning it just like a human and starts producing a new work. It's not possible. That's what Copyright Office, American office said. How it created? Because you are given a prompt. In a recent case also, whether you giving, how you give a prompt to Chat GPT, you will type, please, you write a 100-page project report for me. Your LLB student asking to Chat GPT because he was enjoying somewhere in Vishakhapatnam malls. He forgot to write a project, and if the last date of submission is tomorrow, he will request Chat GPT G, please, Chat GPT Garu, నా కోసం ఒక ప్రాజెక్ట్ రిపోర్ట్ చేయండి. He will give a written prompt, typed one. Or you can use the voice prompt also. That facility is also. That's what Copyright Office said. You are prompting, then it is creating. From where it is creating? The available material. Last month, I kept harassing the Chat GPT. complicated prompt as given. And as I expected, it could not create any content for me. It started, the uh, uh, buffering. After 5 minutes buffering, it came out with a reply. There is a lot of traffic and busy we are experiencing. Please wait for a while. After 15 minutes, I gave the same question. Same thing came, same thing. After 2 days, I said, same reply came. So what I have done, I said, why you keep repeating the same thing? Lot of traffic is there. We are going busy. We are not able to generate this. Please wait. Why are you asking this thing? And what is the reply I got? The same reply I got. So I said, you are very lazy and inefficient. And no reply from ChatGPT. So I took a screenshot and put in the Facebook. Who is the first person to like? Very famous IP and copyright professor from European Union. His name is Mark Lemley. He put the laughing emoji there. So and started people talking about that, discussing about it shows the efficiency of artistic literature. If you go to library, if the material is digitized, then only it can give you the data and write an article to you or a project report to you. But the books are physically available only in the library. ChatGPT can't walk in the library and borrow a book or sit in the reference library, start reading and giving you. Unless until that is scanned and uploaded on the internet or database, it can't access it. Then, even though it is available over the humongous data in the Google or internet networks, it collects only few things. I tested that also. It can't do everything and give you. So it is very important to know that these artificial intelligent machines or artificial intelligence, they are no match for humans. Recently, I give you another example. Young lawyer in United States, Washington, he used ChatGPT to file a petition. So it gave 6 important judgments with analysis. When judge read it, he found it all these references of 6 cases he never heard of. He employed his researcher and starting to find out that later he came to know that these 6 judgments never delivered by any court in this world. These are the fake and bogus cases created by ChatGPT collecting some information out of internet networks. This guy, instead of doing the fact checking, very, very important to do fact checking when you use this kind of artificial intelligence machine. He felt very happy, took a printout and signed it and put it up in an affidavit template and submitted in the court, and he was caught red-handed. So this kind of embarrassment people are facing because artificial intelligence. How can you give rights to artificial? It is a non-human. We are natural persons. What is artificial intelligence machine? It is a general purpose assisting technology. It can't replace Dr. Purushottam, Dr. Vijayalakshmi Garu, or Dr. Krishna Mohanji, or various n number of professors are there, and it just can't replace. It will assist preparing a lecture notes, collecting information ready-made on any other new topic. That's all. Similarly, lawyers it may prepare a template MOU, a template affidavit, template bail application, a template soft contract, all these things, but can't. That has to be again fact checked, read carefully before that is signed and used in the legal manner. And then similarly, judges, in the e-courts phase 2 recently, government of India spent a lot of money and they introduced video recording facility, not only in the district courts, high courts and Supreme Court. And no one was using. Thanks to COVID Mata, she came, she locked out everything. And for the access to justice, they took out old photo or and dusting their machines and started using video conferencing. Then India became a leading country using ICT facilities for access to justice, court hearing through the video recording, right from the Supreme Court to high courts and all. Now we are moving into third phase where artificial intelligence and data analytic tools are being used. These are going to be assisting tools for the judges and lawyers. They're not going to replace judges. They're not going to replace Justice Chandrachud of Chief Justice of India or any other judges. It's simple. So it is very, very important to know this aspect. And then people talk about the most important issue recently is the example I've given, generative AI, like the Mid Journey or Stable Diffusion, mimicking the songs of singers after the learning and singing in the same style. So singer said, I have not given permission. So how can you do this without my consent, without my permission, without giving any royalties or compensation to me? So how will you address in the Indian Copyright Act if this happens? Best thing is said, I say that it is not an original work. Why can't a machine sing like you and me? When you and me or anyone start singing, we sing with our own voice. If you are a learned singer, you sing with raga, tala, with sur and all that. Or besura, people will run away. So why it should sing like a Balamurali Krishna, Manganampalli Balamurali Krishna, or Gandasala or Balasubramaniam, or other living artists? Why it should sing like that? Yeah, it cannot. So it is creating only a derivative work. What is the difference between a derivative work? Derivative work is an adaptation. If you take out the Copyright Act definition, first definition is adaptation. The adaptation of a dramatic work into literary work, a literary work into dramatic work. There are so many AIs have come. What are these AI? You put text that will become an artistic work. You put an artistic work that will convert into literary work. So these kind of artificial intelligence, generative AI things have come. All these things are doing only adaptation only. What is the rule of adaptation in the copyright law? Any adaptation, which may be a translation, which may be a new work you are creating, literary work. Chetan Bhagat wrote 5 point someone, and it's been adapted into film script, and Three Idiots film has been made. Like many novels have been converted into film, adapted into film. Question and Answers is the book written by Vikas, IPS officer, Vikas Swarup. What happened to this book? This was adopted. A Slumdog Millionaire film came out. Donny Boyle film. So this is called adaptation. So while adapting, you have to give some money. First, you have to take a consent. That is the exclusive right given to the author, any adaptation right. You just can't go and take from the internet, start doing the work thing. It will be an infringement, and the infringement suit may run into lakhs of rupees. So one should never do. So it is a derivative work only a permission has to be taken, consent has to be taken. So what these GPTs are doing, whether it is the chat GPT or any other generative AI like Stable Diffusion or Midjourney, any other AIs are doing, without consent they are doing. So that is illegal infringement. Then another argument, there's no copyright exceptions are there. Under the fair use, there is a transformative character is there. It is a transformative thing, so no copyright violation. No, it's not a transformative. It's a new derivative work you are creating. That kind of exception cannot be applied. Moreover, in India, we don't have a fair use concept. Fair use is an American concept, Section 107. It is an open-ended concept. The 4 factors test is there. Folsom versus Marsh's American Supreme Court said that the fair use test is passes. What is the purpose? What is the character? What is the extent of work taken? And what is the impact of this work you have created under the fair use on the original author, on this commercial ability to exploit the work? If this test passed, only it is considered the fair use, no infringement of copyright. But in India, and that can be applied to any platform, any new technology. That's why when AI came, ChatGPT came, generative AI came, they applied this, but failed to get recognized. But India, we have a different system. That is common law system we adopted from UK called fair dealing. What is this fair dealing? Fair dealing is that there's a list of works which are not infringement of copyright. So I am giving a lecture to you. Let us say I've read 10 books, 100 articles before and absorbed it and learned it. Like ChatGPT, you ask them, please create a article, 2,000 word article, 5,000 word project report, you may ask. Immediately start learning over the internet, Google, internet, everything it collects and give it to you. But I have to read 100 books. What are the developments happening? And then retain in the mind or put it in a PPT and make a presentation. So how this learning is different from other learning? So this is the very, very important thing. One should recognize that the learning they are doing is a machine learning, is a digital learning. It within a short time it can create. Whereas mine is, or yours, is a physical learning, is a pedagogical learning, is a self-learning. It cannot be matched with that kind of machine learning. Then comes the most important thing in this artificial intelligence technology. That what are the exceptions given to this copyright? Because the speakers before me, they spoke about the exception to the copyright. Can exceptions to be given to the copyright when whether a ChatGPT, what ChatGPT does the moment you ask write 2,000 word article or 5,000 word project report, it collects information from that. 3 kinds of information it collects. One is copyright protected material. Second, the public domain material, means out of copyright exhausted, like the works of Rabindranath Tagore, works of Premchand, works of Mahatma Gandhi. The life of the author 60 years has gone, so no need to take permission. So but for the copyright is subsisting, despite author is dead, but 60 years has not been gone, copyright subsists. So anything you doing, any text extracting, information collection, and these are the various text data mining algorithms, natural language processing algorithms. That's what utilize in the ChatGPT. They learn the language, the models. They create data sets. So creation of data sets is infringement of copyright. If you look at when internet treaties were introduced, WIPO copyright treaty, the very first article it says anything is converted into digital is reproduction. You know, when you have physical book, you digitize it into a soft copy. That is a reproduction. So if that is your own book, you are yourself an author, you need not take permission. But somebody else's book, somebody else is author, somebody else is right owner. You need to take the permission before you digitize or convert in the internet so that ChatGPT will go and start reading and learning and create a data set and gives it. So it creates a data set first. So when you give a prompt, whether it is the word text prompt or a voice prompt, it starts learning. The question comes, all experts are asking whether learning is an infringement of copyright. I say it's not an infringement of copyright. Take you for example, you go to a bookshop, if you have money, you buy 1,000 rupees worth book that is very much prescribed in your university syllabus. You want to have that book and read, sit and read in your study room in your hostel or a home, or you go to library and borrow it and read, learn. So by reading it and learning, are you infringing copyright? Even though you're reproducing it, you are, a kind of data sets you are creating in your mind. You remember everything once you read. That's what the artificial intelligence is doing. But the moment you start writing an article, you have to give a citation. You have to give a referencing. When you're quoting, the quotation in quote unquote in inverted commas, quotation also you can't use paras together and pages together, limited 2 or 3 lines. But that also you have to give a reference. Even you are paraphrasing it, if your English is good, you don't want to use the quotation. You want to simply use in the words, the phrases which you are expert in that way you write. Your own style is in writing because everybody's learning is different, everybody's English exposure is different. The way you use your vocabulary, phrases, and idioms different from the other person. He starts the sentence and ends the sentence. So, and that is your style. And how can it be comparable with the artificial learning machine, which mimics the style, mimics the way you are writing, the way Mahatma Gandhi has written, the way Shakespeare has written, the way the Srinathudu or Suravaram Pratap Reddy or Sri Sri or Veyi Padagalu written by the famous Satyanarayan Garu or Edanapudi Sulachara Rani romantic love books or Endamuri Virendranath books. All these things, it can write. You will be surprised to know that the latest book of that particular your favorite author is come in the market, sold in the Amazon, but author has not written. And it became a bestseller in author got surprised. Oh, Bhaiya, who has written this? The artificial intelligence machine. But that is the big issue. If that material is not available on internet, it can't work. But your learning is different from it. It is not, learning is not, I totally agree with the Japan, which has recently announced the law for the artificial intelligence. The very machine learning is not infringement of copyright, but that learning, the output comes out, then the infringement starts. If it is commercially creating that book, selling that output without a consent, without compensation, without paying royalties, immediately Section 51 infringement of copyright will be attracted, and without license, selling, reproducing, and communicating with the public, distribution is infringement of copyright. Simple. And then coming to the plagiarism. What AI chart GPT does, high-tech plagiarism. The plagiarism machine softwares are available. All your professors aware, your researchers also do that. And they say that similarity reduce karo. Reduce the similarity to 8%, below 8%. What is this below 8%? People think means 8% allowed. That's what the myth circulated. 15%. If you set a rule of 15% similarity, 15% plagiarism allowed. No. Looking at the condition, because there is a referencing, citation, many other things that has to be written in the same form, because you introduction to Constitution written by Dr. V. Vijayalakshmi, publisher Satyam Law Publishers, okay, 1996. Let us say this is the citation of the book. Can I change this? I can't change. I have to write similar citation. Sometimes it may be getting repeated. So this poor machine software will catch that. Oh, there is a similarity. But to avoid this, in some certain system come up. That's all. But ChatGPT generative AI is going beyond that. It is not giving a single citation. I tell you, recently I've written a chapter for a book. Then I got a crazy idea. Small subheadings, I started asking questions. Number one, I was not satisfied because whatever collected information written, 50% also, even 50% ChatGPT could not compete with me in that. So it's not satisfied. Then comes whatever material it has written, not a single source, not a single citation, not a single reference. Then I asked, so whatever 100 words you are written, from where you got it? I put a question. So please cite, please give referencing. After 5 minutes buffering, run, big sounds, it started murmuring. It got angry because I asked for citation. Same when professors ask the researcher student, where is the citation for this sentence? Go back. Physical world, when I did my MPhil in 1989, if I forgot to mention even a small phrase, my professor Radhakrishna Sharmagari, Usmania University Archaeology, made me run to Delhi again, because that book was not available physically. Neither internet, Google was available at the time. And I came back and did a lot of library research and got the information on that. So my machine is not able to give that. So it's high-tech plagiarism. Plagiarism, sometimes there is a single source. So foolish people simply copy one book and submit as a report. Or some intelligent people go and do the multiple plagiarism. About 10 books and 100 articles they collect and try to pass off as if they have written the book. It is again plagiarism. And third one is, this is high-tech plagiarism. It's doing, that is paraphrasing. Collecting information and paraphrase with your beautiful English language as if you are a Shakespeare, the original expression has come out. It never be. So these are the problems the AI creating. So AI cannot be recognized an human author. Forget, people are necessarily creating confusion. It is only, again, I'm saying it is only a technology assisting, general purpose technology assisting tool. It should be used carefully. And is being used. Tomorrow, one professor told me, the IIT professor, no, Raghavendra, there's an ethical question, moral question. I'm coming to that ethical and moral question. when expression is machines, how can you claim you're an author? So you have to amend the Copyright Act. Copyright Act Section 2, subsection C, small 6. It says, who is the author of computer generated works means the person behind the computer, generating computer generated works, he is the author. He said, you simply giving a prompt, asking will not do. It is its expression. But I say it is not the pure, complete expression because it is copying the expression. Let us say there are 50 articles written by Professor Dr. Vijayalakshmi Garu. She is an expert in a particular topic. I will ask my chat GPT, write an article the way Professor Vijayalakshmi thinks and writes. Immediately it comes out the same style of paraphrasing or the subheading or the writing articulation style. That is very, very important. The writing and articulation style differs from person to person. It mimics her style. It copies everything. The moment a student or person known to her, oh, madam has written, very good. Madam will say that no, I have not written. Somebody must have copied it. Uh, this cannot be changed, even though books are in public domain. Copyright exhausted. Life of the author 60 period gone, but you can't take out the name.
I think there is some technical problem at Sir's end, our speaker's end. I hope that you will join us back soon. we are trying to reach Dr. Raghavendra. In the meantime, if any of the participants will have any question, you can write that here in the chat box.
not the machine itself. Then coming to the second respect, right to respect, or right to integrity, I'm telling, these are the learning condition of these authors that is reflected in their works. The great Gitanjali has written, many atheistic, I was studying in Usmania, many atheist people were there, leftist people were there. They used to criticize, why you like Rabindranath Tagore Gitanjali, you keep quoting his poems and all that. I liked it. There is a spirituality in that. Because, can that be imitated by the machine? That kind of respect the Rabindranath Tagore had, reputation had, the honor he had, a machine can't get. So moral right cannot be extended to that. So there are many aspects to this why a machine cannot get a right. I can argue and speak hours together. So मशीन को मशीन ही रहने दो, उसमें जान ना डालो. So let machine be a machine. Don't put spirit into that and start treating like a human. Even though it becomes the next level, a super AI comes autonomously. Even now it is autonomously doing, but without prompt. There is a project our which is being done in the US, that the artificial intelligence and human connection, new technology is coming. It is a kind of thinking technology. You need not give any written type prompt on your mobile or voice prompt to it. The moment you think, I want 2000 words paper on XYZ topic, immediately it catches your thought, it generates that book. Then who is the author? That, and while thinking, you may interfere that no, this paragraph is not like this. You change it, because this kind of technologies are coming. Still, human is there. You can't remove human from anywhere. These machines are going to be only assisting technologies, and I am very vocal against giving any rights to machines. So with this, I would like to thank the Vice Chancellor Reddy Garu and Registrar Krishnamohan Garu, my friend Professor Purushottam Garu, and also the Professor Vijayalakshmi Garu. Jai Hind, Namaste, and if you have any questions, I'm ready to take. Hello. Somebody is there? Ananya, can you please speak? Identify yourself. Dr. Ananya? Mr. Mullapudi Venkat Garu, please, you can ask your question. Somebody asked the question that is there any separate law needed? I don't think there is a need for a separate law right moment, but some guidelines are being prepared by the EU. Started the first step, drafting the guidelines, and the United States of America is in the still the discussion stage. They're exploring the various possibilities, and many other countries are also doing. Japan has done the finally they decided that AI learning is not infringement of copyright. That is the first stage they are already set, which I'm fully agreeing with that. Any other question, please? And should Chat GPT and other problems
We
like
are unable to reach our speaker right now. So I can see there are few chat in the chat box. There are few questions. If ma'am, Professor Vijay Lakshmi Garu, if you can, uh, I would like to request you to take up those questions. Should I read it, ma'am, or you can see the chat? Should I read the question?
please, Ananya, please do it.
Ma'am, you can please unmute yourself. I have sent a request.
Please take only 5 very good questions. The rest of them you can leave it. The best of the 5 only, please take.
And can you please unmute yourself?
Hello. There is a question, very important question, whether who is the owner of AI's content. For example, a data scientist, software person who created that algorithm that created particular AI, or person who was sold in the market.
You might have got one request. We are requesting you to unmute yourself. You have to click OK on that.
Mine is okay. Mine is unmute only. Can you hear me?
Speaking.
I think somebody should intervene. It can't go on like this.
I can hear you.
Yeah, who will be the owner of the copyright? Because the as per the law, I say that person behind the computer generated works is the owner of the copyright. The Chat GPT, OpenAI, even though it is claiming the facility, it can't claim it. Even though it is collecting the information, doing the learning, and giving the topic to you, as long as it is doing freely. Because now most of the AI machines you have to pay. Of course, the latest technology machines, generative AI like Stable Diffusion, Mid Journey, everything you have to subscribe and make payment. Then only they start creating work for you. So you are the one who is paying. You are the one who is giving the prompt. You are the one asking something to be done. So you should be the owner, not the machine or the person who has written that software or algorithm or person who is marketing it. That's what I believe. Coming to photographs, there is a question. Any painting or a photograph it has created. I already told you that if any derivative work, it is creating a similar style and similar thing. It's a derivative work. and no exception can be allowed. But some exceptions are there, parody kind of thing. If that creates a meme, criticizing something, you all know that you must be seeing so many memes in the internet and social media, and such thing, parody and all that, like kind of criticism and review. That's what we call it, an exception given. Such things are allowed under the exceptions only. But commercializing them again falls into the category of taking the consent and paying the compensation. As long as simply creating them and using in the social media, and that won't infringe the copyright. Yeah.
Madam, one question has been there in the chat box. The person who clicked the photograph is the copyright owner. This makes cameraman more rightful over his relating to the what is it? Now, this question can be answered in this way that yes, the copyright laws do confer the copyright protection to the person who has taken the photograph. In this case, that is the cameraman who has taken. It belongs to him. But then, when we have to also look into the another provision, that is a section 17, whereby it says that works, a photograph taken, film made for consideration. So where the consideration is paid, and then under that consideration a photograph is taken or video film and all are made, in that case the owner will be the person who has paid the consideration. And in practice also, these producers of the films or the video films and all, they have the assignment agreement between the cameraman or the photographers and all with the producers. So this is they have to assign the copyright in whatever it is to the producers of the film or video film. So this is the law regarding the ownership and the photographs taken. Yes.
So, can we close this event now? With your permission, Vijayalakshmi Garu?
Yes, sir. Let us close. Ananya?
Yes, sir. Yes, ma'am. I'm here. So
Yeah.
thank you, sir, very much for your time, and thank you, ma'am, very much for. I thank I'm giving my heartfelt thank to both of you for enriching our students with all the information they were looking for, and I thank all the participants for joining this webinar today and making this a successful event. And I also thank our computer center for providing us these facilities and all the access. So we hope that we will be able to see you guys for our future webinars also. Thank you. Thank you very much from Department of Intellectual Property Rights and from Andhra University. Thank you all.
Yeah, thank you, Ananya ji and Dr. Vijayalakshmi Garu and everyone. Thanks a lot, Jane.
So I also equally thank, and I felt very happy to share the platform with the Raghavendra Garu and all the other professors, scholars, students, and also my authorities, my employers, registrars, sir, rector, ma'am, and all others. Thank you for giving opportunity. Thanks to all of you. Thank you.
Thank you, ma'am.